we've now gone live.
Okay.
Wonderful. Greg, thanks for joining us. It's a treat to have you join us on Thanksgiving week. So thank you.
My pleasure. It's great to have you here. I'm happy to do it.
Thank you so much. We've got many people starting to join the room, and it's always great to have the world's best expert on estate planning. And Greg, you have a lot of acronyms behind your name. You have an ESQ, a JD, an LLM, a CPA. Those aren't easy things to obtain in this life.
Yeah, it's if you spend enough time in something, eventually you get enough acronyms behind your name. Also means you've just been around the block a little bit.
Yeah.
So, yeah.
Well, we're super excited to have you. We've got more people entering the room. I'll give everybody about 30 more seconds for those late joiners to join us. But I'm just going to start introducing you a little bit. Gregory S. Smith grew up in Oregon, just comes from a great family, a family of entrepreneurs who are always thinking, working hard, doing great things for the community, for family, and for so many people. Greg is a dear friend of mine, known him for almost close to a decade and a half, and have been working with him on many clients that we work together on, that we collaborate on, and he's just a wonderful person. So listeners, we're excited to have Greg Smith as our guest today. Greg, welcome to the Arista Wealth monthly webinar.
Thank you, Paul. Thanks for having me. I'm really glad to be here. And so for many of you, I've known, whenever you're ready, I'll tell them a little bit about you, Paul.
Oh, you don't want to do that, Greg.
So I've known Paul for a number of years, and how I met Paul, I was in another office, and it was younger in our career, and he walked in and just has such a kind of an endearing personality. I thought, I'd like to get to know Paul, and that was probably 12 years ago. So I've known him since then, and met his clients over time, and he travels. Not just in, he has a lot of clients here in Las Vegas, but he also has them all over the West Coast. Probably some on the East Coast that I don't even know about, but all up and down the West Coast, including many of our friends in Alaska who probably joined us to this morning as well. So, so Paul's awesome. Not only, in fact, this last weekend, we rode 37 miles together. I was riding my bike and I thought, who can I call who spontaneously will just join for fun? And I called Paul, and so he and I rode another 37 miles together, just not last weekend, but the weekend before. So it was a lot of fun. So, yeah, but I'm happy to be here, and I'm happy to talk to you a little bit about estate planning, a little bit more about what my initials mean. I went to school up at BYU, and I got an undergrad in accounting, and then I decided to get a master's degree in accounting, and this is all in a specialty in taxation. And so I went into accounting, and honestly, as Paul said, my family was entrepreneurial, and my dad said when I was in 5th grade, I said to him, I go, what am I going to do in my life? And he goes, you're going to be an accountant. And so I said, okay. And so I decided I was going to do that until I found that your life is locked up from January to August. And so I decided to go to law school after being in public accounting for about 5 years. I was at Deloitte. And so I went to law school, and I ended my public accounting career as a CPA with 10 years experience. I was in Los Angeles with Deloitte as a large accounting firm. And at about 5 years, I went to law school at night. I went here at UNLV. So while I was practicing as a CPA, I was doing law school in the evening. And I wanted a career that had a little bit more interaction with families. My career there was with publicly traded firms. I worked with a lot of high net worth individuals, but a lot of SEC matters, actually. And I wanted to have a little bit more of a family relationship with my clients. So I did that law school thing at night. And so my background is very, very heavy in taxation. There's not a lot of people who've done 10 years of public accounting and then start a career in law. And so I'm really comfortable in talking about taxation. And so that lends itself well with estate planning. But here's what accountants don't know. Accountants don't understand the legal side of transitioning. How do assets go from one partner to another partner? What type of document is it called to transfer something from here to there? Accountants don't work on deeds. They don't work with stock certificates. They don't work with, buy-sell agreements, all these things that really the legal world deals with. But as an accountant, you have tax consequences. So estate planning is really a conversation about what people have accumulated in their life, and they focus their entire life on accumulating. And then there comes a point where families have to start to transition, and they have to say, honestly, what am I going to do with this, and what's the best way to do it? And so the most difficult thing in estate planning is wrapping your head around the fact that you're getting older. And I think that's, I just went to a meeting last night, and the man showed me his whole right arm was completely black because he was doing core work, lifting the ball like this, and he bumped his elbow and his whole arm went black. And it just the easiest little thing, and I'm sure that many of you have had that happen, but it tells us that we're mortal. And so what this conversation today is intended to do is to help you realize that there may be things happening in your life that should tell you, maybe I need to do just a few things. And that's why I call these things tips, because it's tips that are going to help you recognize that maybe a change needs to happen in your current plan. And so something else that I'm going to change the slide here. I decided to put in a baseball motif, and Paul has looked at this seminar. And I never played baseball really, even as a kid. I only played it with my dad. But I tell people I'm watching baseball a lot now. And so I was talking to a friend of mine, and he goes, well, you know why you're watching baseball? And I go, why? He goes, because you're getting old. I've been so impatient all my life that I've never had time for baseball because I thought it was such a slow game. But as an adult, I'm watching some of the unique things that happen, and I have this appreciation. And so I've got some analogies to it. So if I'm going to have hopefully you can see my cursor. Oh, and by the way, if you have questions, you can always type me a comment in the chat box that's to the right of your screen, and I can answer that. So I'll be watching for that. But as with my cursor, I have a baseball tips and estate planning kind of presentation. And I went here basics in estate planning, assets in a trust, and taxes, so I can get the bat so you can remember it, right? And so I want to start off with just something that I thought was really interesting. As you know, the Phillies just played the Astros, but in Game 3 of the World Series, you've got Bryce Harper, and we all like Bryce because Bryce, at least from Las Vegas, because he's originally from Las Vegas. The other thing is that I see his parents every week. His parents actually happen to be in my congregation at church. And so I know his dad, I know his mom, and so he's just kind of a hometown boy. But anyway, it's even more fun to watch the home series. And so he hit a he slugged a home run with not bases loaded, but he got 2 runs in with a homer. And afterwards, he called in Alex Bond, who was new to the team. He's a third baseman, and look what he did here. He started to talk to him about something that he saw. And Hannah Kaiser on Twitter said, here's Bryce Harper after his home run in the first, calling Alex Bond over, presumably to tell him something to look for. What was happening, and people have speculated because no one will actually tell what he saw, but the ball was dropping, and so they knew where to swing. So you can see in the next slide, this tip with Lance Mueller Jr.'s first pitch, Brom lined a home run to left field. Brom knew the pitch was coming. Estate planning is like reading the future like an incoming pitch. And so when we talk about estate planning, we're going to talk about things such as basic as your physical body. What do we do with that physical body? What are we going to do about assets, and what are we going to do about the trust, right? And so those things are important. And even though you might be a novice like Alex Baum, if there's a few people who may have gone down this path ahead of you, who have a little bit of wisdom, and I know I'm 56, and so I even myself have started to appreciate what my clients have been telling me for years as I go through it myself, and hopefully you can see some of those same things. So as we go through this, I'm going to take a slide. As we go through this, I started thinking, how can I make baseball part of my fun conversation? And so I want you to see if you can kind of guess, why would I put a picture of a movie person? And you can maybe in the chat box on your right, how many of you know what this movie is from? It's a baseball motif. What is it? And the reason why you can have some hints here is because I'm going to be talking about some of the most basic things to start. And if you take a look, tip number one, know the basics of estate planning and a will. So many times I have people come into my office and they say, I just want a will. Well, actually, you need a will. Even if you do some more advanced estate planning techniques, a will is important. Why is that? Because the will addresses your physical body and what is to be done with it. So you wouldn't just have a trust, because you need to say, am I going to be buried? Am I going to be cremated? Who am I going to have my remains administered by? If I'm a veteran, who's going to take me to the Veterans Hospital or the Veterans Memorial Cemetery where the veterans are interred? Do I want to be in a crypt? What are those plans? And those things happen in a will. And so as well as a conversation about my body before I'm deceased. And so there's really three things. How is my body interred into the ground? Before I pass away, if I'm sick, who's going to be my guardian managing that? And then finally, there is a section that talks about my assets. And if I pass away, where do my assets go? Well, if you have more estate planning techniques, and we're going to talk about that later, that's a trust. And a trust is not a will, but it's mentioned in the will. So if you have done some estate planning that you put a lot of money and effort into, your will actually says, hey, I've done this plan. It's all in place. I've worked with an attorney. It doesn't say all these words, but it basically says all the rest of my estate, I give, devise, and bequeath to the trust named the Paul Moffat Family Trust. And that's all that is said in the will. And that section is done. And the reason why that's so important is because wills are things that are they're filed, and in the legal community we call that lodged. It's lodged with the court so that the public is notified what happened to the body. We have a right to know what has happened to the body. It's part of our law. And so when you have a will, you're telling the world, according to law, what happened to the body and what happened to the assets that went along with the body. Well, if you have a trust, you don't need to mention anything else except that there was a trust. We don't know what children got the money. We don't know if it was an unequal distribution. And I've seen things in the news and they talk about a wealthy person passing away. I want to find out if the money was given to the children, if there was any intrigue. And it typically says there was a trust, and that's all that the public needs to know. So wills are important because it talks about where the body goes, who's going to be administering it. In Alaska, we have, every state has different form names. But with regards to living bodies, ones that are incapacitated, we have Alaska Durable Powers of Attorney, and we have the Alaska Healthcare Directives. Now, I'm sitting here in Las Vegas. I'm a Nevada attorney. The way that the law works is that any area of law that I am comfortable and technical with, I can talk about. Estate planning, I can talk about. I can talk about your state. If you're in Alaska, as an example, I can talk about Alaska documents. I can talk about Tennessee documents. And interestingly enough, I have not all 50 states, but I have probably a good majority of the states and all their legal documents in our system. So because I have clients all over the country. So I see a comment here from Randall Smith. It's close to being the Fonz. Is there any other comments as to who this is on the right? He's a beginning baseball player in the movie, doesn't have a whole lot of talent and can't stick with it. It's a movie I'm dating myself, but if this movie came out in the 70s, and of course it's Grease, and that's John Travolta right there. Danny. Yeah, there you go. John Travolta, Randall. You got it right. And Greg, just learning how to play baseball.
Yeah, Greg.
Yep.
Greg, we need to give a surprise and a present to Randall. We should give him 2 tickets to a Vegas Golden Knight.
And you know, you're a winner, Randall. You got it. You got 2 tickets to the Vegas Golden Knights for accurately selecting who this is. It's John Travolta in the movie.
Good job, Randy.
Yeah, exactly. So Randy's got that, but Travolta was just getting started with what you would be the equivalent to having a will in place, and it's better than nothing, but it definitely is just a start. So now that you understand that a will deals with the body and that's necessary, let's talk a little bit about the next progression of understanding estate planning. Estate planning, interestingly enough, is handled and done through the ownership of property. And so many of you who've bought homes, you set up checking accounts, you've bought cars, whether you know it or not, we're talking about ownership and how property is going to be recorded. So most people understand owning property in their own name. Joint tenants is very common between husbands and wives, but it's also common between partners and same-sex couples that are sometimes together, or people just, I have a couple that they actually are Japanese descent. They're in their 90s, and they were in California as part of the Japanese internment program during World War II. And two sisters that did a trust together, wonderful couple, and they own property jointly, and they're sisters. And so what does that mean when two people together have property and they're siblings? Well, it actually has some inheritance consequences, and you need to understand it. So joint ownership means typically the survivor gets the property. Tenants in common is also joint ownership, but what it means is, and it's similar and yet it's opposite. At death, tenants in common does not mean that the asset passes to the person who you are a tenant in common with. The tenant in common dies, and those assets remain in the family of the tenant in common, not the person who they were tenants with. So opposite as it relates to death. Owning property in trust is what we're going to talk about. Beneficial ownership. This is something that Paul deals with all the time. He deals with beneficiary designations. And I will tell people, there's some estate planning that financial advisors and wealth advisors will do as part of their business every single day. They have to ask, if you die, where do you want this to go? They have to have a designation. Many times they'll say spouses, many times they'll say children. But what will happen is they'll say, well, don't you have a trust? Would you like to name the trust as the beneficiary? And so it's a conversation. So anytime you're dealing with life insurance, anytime you're dealing with retirement plans, we have a conversation about ownership, and it's called beneficial because if you pass away, who's going to get the benefit of that? Finally, there's the conversation about community property. Now, I always tell people, now when you think of community property, what's the first thing you think about? Kind of a word association game in my meetings with clients. And many of my clients will say divorce. Community property means if I get a divorce, I get half. And I learned what I remember asking my parents when I first saw the original movie called The Parent Trap. I said, well, what's community property? And they said it means this: when you get a divorce, you get half of everything that the person owns. Well, in the context of an estate planner and an estate planning attorney, community property means the surviving spouse gets, excuse me, I just lost an earphone. Can you hear me? Okay, Paul?
Yeah, very great, Greg. Yeah.
Okay, great. So, okay, perfect. So community property means the surviving spouse gets everything. Now, separate property is, now here's a question for you. Let's see if the audience can answer it. Do you have separate property when you're married to a person? Do you have separate property when you're married to a person? You obviously have separate property if you're single. It's all your property. But if you're married, can you have separate property? Paul, you can answer verbally if you want to answer that one.
Sure, Greg.
The answer is yes.
Sure, Greg.
Yes, you can. Separate property can occur if you have a prenuptial agreement. It can happen if you inherit property from your parents. It can also happen if you have a personal injury award and you're injured in a car accident. Imagine if you're married, you get into a car accident. Did your spouse help you earn the personal injury award in the car accident? No, it's separate property. And the reason why I bring it up is because separate property is treated differently than community property at death. Now, most of the West Coast states, well, California, Nevada, Arizona, Wisconsin, not Oregon, not Washington, yes, Alaska, those are examples of community property states. New Mexico, Texas, everything that goes along the base, we skip Oregon, Washington, jump up to Alaska. That those states are community property states that mean upon death, the surviving spouse receives all community property. However, separate property is not necessarily inherited entirely by a wife or a husband. It is actually split between the children. And this even becomes more complicated if you have a blended family. And so if you have a spouse who's your current spouse, but she has children from a prior marriage and inherited property, we have to have a conversation about how we hold that separate property title, just so that things go smoothly if that spouse passes away. So why is understanding how you own property important? Because when you go to the next step, here we have another show. How many of you can kind of guess what baseball movie this one is? You can comment on your right, but on your right, you'll see Tom Hanks talking to an individual. I don't know what her name is, but he's trying to do it in the nicest way possible as a man as a baseball coach, and yet trying defensive, trying to tell her object of the game and to give her a tip. And he's trying to make it get into her head that this is going to be okay. And I will tell you, that's what I do when I talk about trusts. I have to tell people a trust doesn't mean you can't have something. And I even used to use my hands, although when I was in accounting, they said, take your hands and put them on your lap when you talk to me. So I won't use my hands like that because it can be a little bit in your face, just a little bit. But I appreciated Tom trying to do this. And so what is a trust? Well, a trust, you might think that the attorney creates it, but literally the person who's drafting a trust is not the attorney. It's you. You hire me. So when you build a house, you can say, yeah, the general contractor built it. But when you're at a dinner party, you're going to say, I built the house. Well, you really didn't build the house, and you really didn't build the trust, but yes, you did. You built it. And Tom Hanks is not going to go hit that ball. But guess what? He made that ball get hit by his explanations. And so you adopt all of the words that your estate planning attorney drafts for you in the trust. And that's why the trustee has to learn, or excuse me, that's why the attorney has to be kind of a learner. At the end of the show, Tom Hanks was a different man. He sat there and he listened. He wasn't such a screamer as he was in the beginning of the show. And as an attorney, whoever you pick as an attorney has to be someone who has the ability. This is something that I've learned in my practice. I'll go like this. And I listen, and I look like I'm kind of bored, but it allows people to talk to me as I have to listen to them tell me about their family. And have you ever heard that conversation about the difference between a human being and that's what he said, Randall. I'm looking at Randall's comments. Randall's really with me. Don't cry in baseball. That's what he said. Don't cry. Now, if I told that to people in my estate planning conversations, you can't cry when we're talking about trusts, I don't think that would go over. You can cry, and I hand out tissues when that happens. But you do need to share your feelings as part of doing an estate plan. And so I'm talking to creators of trusts. I'm giving them comfort that you know what, you can do this. They are typically the trustees of their own trust. And you might sit there and go, well, a trust, what is a trustee? It's a person who's in charge of a trust. And generally what that means is the very person who owns the asset is going to become the trustee. So it's like taking my phone and I own it as an individual with my right hand, and I move it to my left hand. I still own it, but I'm owning it with the hand that has the ring on it. So it's a different hand, slightly different type of ownership, and yet it's different, right? And that's what a trust is. A trust lists the powers that I'm going to continue to hold. And not all trusts are the same. Some trusts have certain powers in the hands of the trustees and others don't. But a trust is not a trust unless we move property into it. So how do you move property? You talk to Paul Moffat when you're moving your brokerage account or life insurance that's going into it. You talk to your attorney if he's going to prepare a deed. You might talk to an accountant who's preparing a corporation or an LLC, and all of those things need to be put in the trust. A lot of times I end up moving a lot of things except the financial matters, which I leave up to the advisors, but I'll move corporations, land, not bank accounts. That's always left up to my clients to do that part. But that's a really important thing to understand. By a show of responses, just so I can see people replying to the chat group, how many of you have had trusts in the past and have created a trust for yourself? And how many of you have said, you know what, I'm looking into it, I'm in the process, but I've never done that? That'll give me some good feedback to the people that were kind of watching online. Finally, the creator of a trust has beneficiaries that are named. So if your tip number 2 is consider a trust for yourself to own your assets, so that at some point change your way of thinking, just like Alex Baum did, and said, you know what, I need to stop buying all of these larger assets as my wealth accumulates. Why am I continually putting them in my name? Why don't I put them into a trust? And that will, yeah, there Randall's on it. He's got his trust complete. So you've got beneficiaries in the trust. Many times it's your children that are named. So let's continue on as we keep going. Next. Here we have a situation how you have the ability to hit a home run, right? How to hit a home run with a trust. You're able to avoid probate when you transfer property to a trust. But one of the most common things, and I've talked a little bit about that first little section on this slide. I'm going to jump down to revocable versus irrevocable. Many of my clients ask me, Greg, what's the difference between these trusts and why is there a choice? Well, a revocable trust is what most family members have when they are simply trying to avoid the probate piece, which means, as I said in the beginning, the will says that I addressed my assets in a trust and now it's over. That's all I needed to do. It's going to be held privately, not publicly. Now, what's nice about a revocable trust is that you can be a young couple or a middle-aged couple with adult children who are just getting married. You don't have any grandkids. And as your children get married, you can add sons and daughters-in-law. You can add names for grandchildren because your family ends up growing like a tree, and you want to be able to continue to bless people and include people in your plans. And as I will tell people, 40% of my clients disinherit or eliminate beneficiaries. So it's very, very common to have life happen and to have situations where we want to not have individuals involved in our estate plan. And so that's also an area that I deal with. Now, what is an irrevocable trust? Sometimes having power in your own hands is a bad thing. What happens if you are a harm to yourself? I mean, as I was driving over today, I got a call from a family whose parents have gone through a difficult time, and the mother was found in the street over here on a busy road over here, and the police had to be called. Why is that important? Because she's actually a danger to herself at some point. And so if you had a trust that was tailored for someone who was dealing with dementia, Alzheimer's, Parkinson's disease, why are these things important? Because we want to give the power of those assets to a family member potentially to go ahead and take care of that same person. Well, in a revocable trust, you haven't given up any power at all. You've simply avoided probate. In an irrevocable trust, you're actually addressing a specific issue that you might have, and you're turning a power which, if left in your own hands, is going to do harm to you. And so now we're going to give it to someone else for your own benefit. That's one way that an irrevocable trust deals with the creator of the trust. But an irrevocable trust can also be dealt with in terms of helping younger generations. So there's two types of irrevocable trusts that we're going to talk about in this conversation, and I'm going to try to split those up. So this is kind of like a tree that's growing a little bit in our conversation. So the first thing that I want you to understand is you need to understand the basics. Now we're going to bat. We're talking about assets in a trust. And we're saying, okay, we need to move what we own into a trust. There's two types of trusts. And now we're going to continue on with the slide. Now we have another slide on the right. As I'm talking, I want you to think about what movie this talks about. Now we're talking about assets into a trust and asset protection trusts. Not a trust that's created for someone with Alzheimer's or dementia or Parkinson's, but we're talking about trusts that are created for the benefit of the creator of the trust. And the power that they have is the power to get involved in risky things. So you might be an OBGYN physician and you're delivering babies, and you know that it's only a matter of time. Statistically, once every 3 years, there's going to be a lawsuit where you're named because there was a bad outcome. You have a power with your own hands to cause death, and you deal. How do you protect yourself? And like we have in Las Vegas right now, and you probably have anywhere where you're located in this last kind of booming economy where things were going up so fast, the housing product is not as good as it can be. and you're worried that there's some liability out there, but that liability is not evident yet because we haven't had any construction defect lawyers getting in there and taking a look and getting control of the HOA board and creating a big stir and going back and naming all of the developers that were involved in this. How can you be certain that you really earned the money that you earned when the look back can be 5 to 10 years when it comes to something like a contractor? Well, now we're trying to protect you from a risk that you have in your own hands, but I don't want it to be fraudulent at the same time. And so how many of you have got this? There, Randall is just like, there's 2 more tickets. There's 2 more tickets, Paul. I mean, Randall's got a lot. He might have to give him a season ticket entrance because Randall Smith, one of the observers, got the Sandlot, and the motif there was that dog. I don't know what the name of the dog was. This is for bonus. If Randall, he's probably going to Google it, but the dog is, maybe the dog's name is Killer. But the ball went into the junkyard area, and the baseball players wanted to get it, and so I can't remember the hero baseball player is so fast he jumps over to the junkyard fence to retrieve the baseball that was hit into the junkyard, and the dog is saying, "Hey, you can't take this from me. You can't take this back." And so that's kind of the scene that you see here. So what's the relation to asset protection? You can protect things, but sometimes you can't. There you go, Jeffrey. Thank you. Another person, Hercules was his name. Hercules is the dog's name. In the end of the day, it's kind of like asset protection.
Good one, Jeff.
Hercules is there to protect the owner's property and protect the owner's right. And the owner came out and said, "Hey, listen, Hercules is a nice guy. He's not scary." And they came in and they got to know the dog, and it wasn't a bad thing. An asset protection trust is just like that. Take a look at the red thing I said at the bottom. Irrevocable does not mean you can't access the trust. You can come in. You just need to say hi to Hercules. And who's Hercules in the context of an asset protection trust? Right up above it, where my arrow is, there's an investment trustee and a distribution trustee. The distribution trustee is Hercules. The distribution trustee is the person who says you have permission to enter. And what are the rules that the distribution trustee has to follow? Well, you wrote the rules. The rules are, it's me, my spouse, and my kids. And those are the people who get to come in. Plus anybody else that I want to come into the Sandlot or the junkyard, as the case is. So there's a few states that have these types of asset protection trusts. So let me go back to the top of the slide. A conveyance to a domestic asset protection trust is asset protection if it's not for fraudulent purposes. So let me go back to this. There's about 7 states that have made it possible for you to transfer an asset to a distribution trustee and you did not have legal ownership. Okay, so let me give you an example. Paul Moffat is a fiduciary. He manages brokerage accounts. Does he own the brokerage accounts? Well, kind of. The word fiduciary means responsibility. And while they're in his custody, he has a certain kind of ownership. He has the ability, if you've given him the permission, to make investments, to go in and out of trades, and to have a certain type of control that many owners have. You've turned it over to that person. Well, when you have an asset protection trust, and what you've done is you've turned over one power, the power to distribute an asset to a person. It's a human being. And you might think, well, I don't want to give him that power. But haven't you already given that power to your bank? The bank has your money. If a robber came in with a gun and said, you know what, give me the money in the bank, they'd say no, and they have protections for it. That's what the distribution trustee does. Now, when you walk into the bank and you say, I would like to make a withdrawal out of my account, they look at you, they see that there's no one with a gun to your head, and so they say, here you go, here's the money that you'd like to take out. No problem at all. Well, how do you have that type of an arrangement when you have a cabin up in the mountains, or for my friends in Alaska, out in the bush, and it's got a float plane, and you put $1 million in there, and you turn it into a guide, essentially. Or you've got a plane, you're up in Utah, and you've got a cabin up at Deer Valley, or in Nevada. We have a very small mountain with a very small area for cabins, but most of our Nevada people go up to southern Utah, or they'll go down and they'll have a beach house down in Carlsbad, California. How do you protect those high net worth assets? It's always for you, But if someone were to sue you, there's a lot of equity in things like cabins. Well, if I had a lawsuit against myself, or each of you had a lawsuit against yourselves, what would happen there is, if you lost, there could be something called a debtor's hearing, where a list of your assets is accumulated. Well, the things that are inside of an asset protection trust, you don't own. They're not your property under state law. And Alaska was the first one in 1997 to pass this law. Nevada is another state in 1999 passed its statute. So it's 23 years old now. We've had it in our state. It's well settled that these are valid. And across the country, there are states that are trying to get these laws passed so that the people in their states can get them. However, depending on the state that you're located, the legislatures aren't in favor of providing asset protection to wealthy individuals. They want your assets to be porous. They want the trial attorneys to be able to sue you. They want no limits to be to the things that they can claim. And so to counteract that, asset protection trusts are quite popular. But take a look at bullet point number 3 and 4. There is a 4-year look back in Alaska for transfers where they could possibly be construed as fraudulent. In Nevada, it's only a 2-year look back. There are some jurisdictions outside of the United States that have a 0 time period look back or a 6-month look back. That's why people have offshore trusts. Randall asked a question, would they be protected in a revocable family trust? And the answer is no. The reason they're not protected in a revocable family trust is because you retained a power that allowed someone else to be named as a beneficiary. Revocable trusts are just by that. They can be changed. And as a result, you can be compelled to pay someone. And because you are the trustee of that trust, you can use that same power to take assets out of the trust and pay off the debtor. And so that's the problem with a revocable trust. It's actually not a problem. It just is. I mean, a car can't fly. Do we get mad at the car for not flying? We don't. A car is meant for driving. A revocable trust is meant to protect your children from an inheritance standpoint and to avoid probate. It doesn't do anything else. An irrevocable trust, on the other hand, is not intended to efficiently. I mean, a plane can go on a road, can't it? It can taxi. It can move up and down like a car, but that's not what its primary purpose is. So the asset protection trust is actually linked to your revocable family trust with a sentence that says, if I pass away at my death, the assets in this asset protection trust go into the revocable trust, because who knows that 20 years after creating the asset protection trust, I have 10 grandkids, right? And so you do not want a Paul Moffat to be the distribution trustee and then also raise your grandkids. That's not his role. His role is to protect your brokerage account while you're alive. And while you have that risk of your dental practice or your medical practice, but upon your passing, it's going to go back to a family member. Then Paul actually can't be the distribution trustee because he has a fiduciary duty to manage investments. But we would talk to you about who can help you on that. So the sandlot analogy is meant to show that Hercules can be scary, but really he's a protector. And that's what his job is. And you and your family just need to get used to that. He has a role. And at some point you won't need Hercules. But while you're playing the game of life, and you're going to hit a foul ball occasionally, it just happens. That's when the trust is needed. Okay. So moving on, let's talk a little bit about, this kind of goes into talking about assets again. Now, there was a movie that talked about this person, and this is another question on the right. Does anyone know on the right who this famous first African-American baseball player that played with the Dodgers, roughly in the 40s, I believe, who might that be? There was a movie made about him. And I actually looked at the images and I thought, this is a better image of that actual player. And so the whole motif here is he's coming in.
Gregory, I also went down to Dayton, Florida, Dayton Beach, where he made his first debut in the Double-A baseball 2 years ago. This is a really famous player. This is for sure 2 tickets to the Golden Knights. This is for sure. His number is honored every year. His number is honored every year in every stadium, in all 30 stadiums.
Rick got it.
Yes, Rick
got
Watson,
it.
2 tickets for you. Yes, Rick. Yes, well done,
Good
Rick,
job,
all the
Rick.
way from Anchorage, Alaska. Great job.
That's awesome. Well, you know what? That's awesome. That movie 42, Jackie Robinson. I saw a lot of images, but this was the best one that kind of pulled into me. You know what? Safe versus not safe. Your irrevocable assets are going to be safe. And going back to the question that Randall Smith asked, are they safe inside of a revocable trust? They're not. They're not safe. You're out. They can be claimed by creditors. Now, they are safe in the fact that they avoid probate, but they're not entirely safe as it relates to those other things. So if you're a dentist and you have a license to practice dentistry, I cannot take my dental practice and put it inside of an asset protection trust because the distribution trustee is not a dentist. He doesn't have the skills to do that. So there are some things that you simply do not part with, but that are valuable. You want to avoid probate. So your dental practice, your automobiles, your snow machines. We don't have a lot of snow machines here in Southern Nevada, but in Reno we do. Boats, airplanes, float planes, all of these things where you'll take guests, where you can have accidents. All of those things have a lot of value, right? But they also carry with them a lot of risk. And rental properties are an interesting thing. I have to start dealing with comparative risk, right? I've got a commercial property that may have low risk, high value. I might want to put that in an irrevocable trust. So every item needs to be looked at closely. And that's why when you talk about tips, we need to understand asset protected versus non-asset protected and where to place it. The actual answer that I say is all of your assets go in your revocable trust, except the ones that don't. And so those are your personal residence, your cabins, your brokerage accounts. And when I say brokerage accounts, I mean brokerage accounts that I'm not using as working capital. I'm just mainly using them to grow. Then collections of art, valuable personal property, savings accounts. Those are the things that go inside of your irrevocable asset protection trust. And remember, irrevocable doesn't mean you can't get them back. They're simply reserved for you, okay? And so, Jackie Robinson comes in and he steals home, and suddenly the pitcher, the person who has the ball, says, "You're out. I'm going to try to get you." Well, you have got people who are, unfortunately in this world, predatory, and their job is to get you out. Their way is to, your failure is their success. And unfortunately, my colleagues in the personal injury world and trial attorneys sometimes will take up claims that their clients will simply pay them. And so we've got an offset. And the key is you must get to home plate before the lawsuit happens. You've got to be able to do that. You've got to be able to do the trust before the lawsuit has arisen. Otherwise, you actually have a look back period where they can say, "Hey, you know what? We've got you out even with your asset protection because our claim predated that." Okay. So, but you also can't have if you have an asset protection trust and you don't put things in it, you're not going to be protected either. That's why ownership of asset, that basic thing that we talked about. We talked about what is ownership with the Field of Dreams, issue there with Kevin Costner. That image, we didn't actually get tickets for that, but that's okay. We've moved on. Okay, I'm moving on here. Now let's go to the last part. This conversation just on taxes alone, I could talk for an hour. And I've got 15 minutes left. I want to give you some time to talk, but this gets really kind of complicated. Taxes. I'm going to jump to the bottom of the screen. There's income taxes. There are estate taxes. I want you to think about property taxes. I want you to think about sales taxes when you go to the counter. For my friends that are up in Oregon, they don't have any sales tax, so they kind of look at you like you don't know what you're talking about, but everyone else has sales tax. What we're talking about is a tax that is imposed upon your estate if it reaches a certain threshold. So estate planning and planning for estate taxes, we have a number of techniques to minimize taxes that can be incurred on families that have high net worth. But we're in a period of transition, kind of like our economy right now. We're in this place where we're wondering where it's going to be going. At the bottom of the slide, if your estate size is 10 million or more, you really need to start considering taxes at your death as a real thing. Why 10 million? Because if the Republicans and the Democrats don't get together to permanently put some estate tax limits in place that are greater than $10 million, we're going to revert back to $5 million a person that they can die with tax-free. 5 million for one spouse, 5 million for another, adjusted for inflation. That's going to be the limit. If your estate size is less than $10 million, financial advisors will say, don't give it away. You need to keep at least 10 million in your own name, because you're going to have that much money to live off of the interest. So you don't want to hurt your lifestyle for yourself, but you also don't want to have to pay tax. So years ago, people were giving things away because they were worried about taxation. And then what they found out, and I've had this happen with a few clients, they don't have enough money in their name to live out the rest of their life comfortably. And they ask for the money back from their children. They ask for the business back. They ask for the insurance policy to be done, because we don't want to keep paying premiums on it. Sometimes you get ripped off by life insurance salesmen that say, you've seen all those advertising on Fox News that say, we'll buy your life insurance policy. I mean, it happens all the time. You spend all this money on a policy and then you give it up because you'd rather have the money, the cash surrender value in the policy, rather than your children with the death benefit. This all happens if you've talked to an estate planning attorney who didn't plan properly and you didn't catch this little tip right here. You don't need to give things away. You keep it for yourself. And that's one of the most surprising things that clients will hear. You don't need to give it away. Keep it. There's a lot of benefits to keeping the assets. One of the most common things that people like to do is give their house away to their kids before they die. And I think they do it because they love their kids. I'm going to give you the house. Well, guess what? There was the thing called step up in basis, which means you inherit the property from your parents when they die at today's current value. If a parent is really nice and says, take my house that I bought in 1972, guess what? The person inherits the property at $10,000 that they bought the house in 1972. It might be worth $400,000 today. If it's in California, it's going to be worth $1 million, right? Well, I'd rather inherit a property that I could sell for $1 million and pay no tax than be gifted property that had a basis of $10,000. I inherited at $10,000, I sell it, and I have to pay 28% capital gains tax in California, right? Or 33%. So estate planning for 10 million or more, that's where the conversation's gone. Up to this top slide. Right now, thanks to the Trump era tax rules that were put in place through 2026, you can give up to 24 million to your children through 2022. It's adjusted for inflation. It goes up to 25 million per couple. So if you're over $10 million, this conversation's for you. If you're under $10 million, I still want you to stay on because you might get some more tickets because we have some more baseball analogies coming up. So you can do some gifting, $16,000 per year. The tax on those exceeding the 10 million after 2026 or after 2025 or today, it's about a 40% rate. So let's move on. Now here's an analogy. Here's another analogy. This hit the ESPN highlights in the World Series, and it happened when Alex Bregman caught a one-handed catch versus Jed Gyorko of the Phillies. And why is the analogy here? Because it just doesn't seem fair. In my opinion, it doesn't seem fair that this young man can pick up with one hand on the fly. I mean, this ball was on the bounce and it was 2 inches off the ground, and he reaches down there and grabs it and makes this unbelievable play. Well, does it seem fair that I can gift something to a child and yet I have the power to take it back, right? My mother had a term for that and she was born in the late 30s, in 39. And mom, I can't even say the word that they used to call it, but it's when you give something and then you take it back later. And that's not really a gift. And the law says that's not gifting. Well, guess what? When you have a certain type of irrevocable trust called an intentionally defective trust, you can gift $1 million, but you can take it back as long as there's a power in there that says, I have the power to substitute. The red. the power to reacquire trust corpus by substituting property. So if I placed a plumbing business into a trust and I said, you know what, my son's not really doing well with the plumbing business, but I need to get the size of my estate reduced, I can take my plumbing business back and I can give him a promissory note. And the trust let me do that. And I mean, I would love to do that with Christmas gifts, right? You know what? I gave you this nice little, I'm going to give you a Red Ryder gun, right? But I don't want you to shoot your eye out. So guess what? I'm going to take my Red Ryder gun back, and I'm going to give you a little horse, right? That's what this trust does. It just doesn't seem fair that you can do that. So why is it so powerful? Because here's Bregman throwing to first on the run, right? Getting ready to throw this. You have just gone ahead and gifted something away, but look at this. The grantor continues to pay income taxes after the gift. How does that work? Well, the IRS says if you keep a power to take something back, we're going to put you on the hook for paying taxes because you never gave it away for income tax purposes. Well, if I'm a family that's got over $10 million and I've got a young couple that's just trying to save for money in California or Alaska to buy a home, I'm wanting them to save as much money as they possibly can. So why don't I give them a 50% interest in my rental properties and they own it so that when I die, they don't have to pay the 40% tax. But the rental income that's coming in, I'll continue to pay tax on the whole of it so the kids aren't suffering from that, right? And so that is another way to decrease the size of your estate while efficiently making the pass to the next generation. Okay. So I'm going to, so why do I talk about the,
Greg, someone who also uses, who used an IDIT and is very well known. He's a senator from Utah, Mitt Romney. Technique that he used when he was doing so many great things. But
well, it used to be when I was at Deloitte, and I'll tell you a little bit about pricing just for a minute. When I was at Deloitte in Los Angeles, our minimum fee for this strategy was $100,000. Now, $100,000 in 2001. Okay, imagine in today's dollars what $100,000 would be. Is it $200,000? I know that houses have doubled in prices, but anyway, it was expensive. Well, these days you're doing stuff like this and this type of a strategy for $15,000 to $20,000, 1/5 the cost, and that's because it's become much more commonplace. Now, the larger the estate, the more assets that are there. That's what causes prices to vary. But still, it's something that's very, very useful and used by everyday families, not just senators. But senators were the ones that started it back in those days, right? So we just moved this. We just moved the slide. How do we do that? Well, first, one of the things that my clients worry about is if I gift something to my children to reduce the size of my estate, they don't have the skills that I have. They don't know how to make the business transactions. They can't keep the plumbing business going well. They can't keep the linen business going well. They don't know how to manage the stock portfolio. So what if we put land, rental properties, securities, or a business inside of an LLC, and then we transfer to the children non-voting units so they can't control the direction of the business. I've kept the control of the business, and yet I'm going to value what I gave them, right? So that gift all of a sudden isn't worth dollar for dollar what you think it is. There's actually a discount on the gift of 35%. And so with that discount, what you might take, a $10 million gift is now going to be reported to the IRS at about $6.5 million. Or instead of being limited to gifting 25 million because of the threshold, I can actually gift 35% more. And now I can give $33.75 million for those estates that are really high up there. Now I typically am not doing that much. I mean, this last in December, I had two families that gifted $25 million apiece just to take advantage of it before the expiration. But many of them have to balance their ability to have income after the gift, because remember, you're giving something away. You have the responsibility to pay taxes, but it's not your income anymore. So you really are gifting it away. You don't want to hurt yourself. So how do you, there was one slide that we're missing right there. I think, let's just see here. There was one slide that we're missing, and it had to do with how do you make this work a little bit better, and that has to do with the selling of the units as opposed to a gift. If you actually don't gift the units, but you sell them to the IDIT trusts for the children, then what happens is that the children have to make payments on the notes. So even though they have a gift of the asset, they turn around and give the cash flow back to the parents so that the parents have the ability to live and to pay the taxes. So that's a real nice hybrid approach. The problem is that you don't use the annual gifting. It's gone. It's not there. So we've got an hour. I'm opening up for a few minutes for questions. Any of the questions that you might have, Paul? Anything else that you think I've missed? Oh, no, I'm going to go to the next slide.
I did put a poll up, Greg. Yeah, I put a poll up, and I put this also up for Nevada. If you can just quickly address that, 10 seconds or less.
Sure. So asset protection trusts are intended for certain types of assets that don't already have protections. So brokerage accounts, cabins. But in our state of Nevada, and every state is different, there are certain things that are protected. We have a homestead, so houses don't necessarily have to be in a trust. If we've already got, if you do a homestead filing, the house is protected, but it's only your personal residence. If your retirement accounts are absolutely protected. I always use this example. O.J. Simpson allegedly did something wrong, but why is it that he gets his NFL pension? And the reason is because it's federally protected retirement account. And so that can't be touched. But every state has certain specific protections. There's also federal protections like bankruptcy. In our state of Nevada, life insurance, both the cash surrender value and the proceeds are asset protected. So talk to your attorney. We also have a lot of this research on many states in the West. And so we can advise our clients on whether or not, if you can't put them inside of an asset protection trust, why not put something in and overfund a life insurance policy? It's a great asset protection technique. 401k and IRA, absolutely perfect to think about saving an asset so that if a creditor tried to attack you, they couldn't do it. But you know, I appreciate your time. I appreciate the comments from all of you on the right side. And if you ever, the first slide of this presentation has my contact information. My email is gsmith@smithshapiro.com, and I'm happy to take your emails or your calls, and we can just kind of go from there. Last few moments, it looks like we have about 3 minutes. If there's any questions, we can do that. Just as kind of as a show, would you mind just typing in and just saying what state you're from? Just type in, you know, here's my name, I'm from this state, so I can kind of get an idea as to who I was talking to today, and I'll be prepared to kind of see and look in the very different state differences. I would sure appreciate that if you have the time, and if not, no problem at all. We'll probably do this another time, and we'll see you on the next one. Paul, anything else?
Greg, we just ended our poll. 60% of the attendees today have trusts, and 40% don't. So okay. 60-40, it's actually a little bit higher than normal. Usually it's 40% have and 60% don't. So we have a great group of listeners and participants who are protected and are following some good advice out there. So that's exciting. And we'll make sure we get these tickets out. We want to be sensitive of the time. We want to say thank you so much, very, very much for joining us today. Greg Smith, world-class expert in regards to estate planning with an overlay of tax. If you have the time, you have questions, feel free to reach out to him. He's one of the best out there. And we're very grateful to have you join us today, Greg. And we want to wish everybody a wonderful, merry, happy Thanksgiving this week. Hope you're around your family, friends, and hope you eat everything you want to eat. This is a week that calories don't count. And but go out there, have a great week, and thank you for joining us. And next month we'll be talking at our monthly webinar about tax things to do before the year is over. And so we'll send that out, and we're really excited to have our guests join us next month, and we'll get some information distributed. But have a happy Thanksgiving. Have a great week, and we look forward to talking to all of you soon.
Thanks, Paul. Thanks, everybody. Appreciate it.